Now is the time for us to answer the question, what is the legal liability of auditors? Before we do that, let us define some key concepts. For example, the sources of law for a possible case filed against the auditor are common law, meaning those which are written opinions of prior courts, and statutory law, meaning those which are passed by legislation. Another key question we need to answer is, who can sue the auditor? Who can be our plaintiffs? Well, for us to understand that, let us get to know some important personalities first. So here we have the external auditor. The external auditor signs a contract, usually in the form of the engagement letter, with the board of directors who, in this case, represents your client. It is also possible that there are third-party primary beneficiaries. This is a third party who has been specifically identified to the auditor and is thus known to you. An example is when an audit report is requested by the company because they will get a loan with the bank. The client is the company and the third-party primary beneficiary is the bank. And then we also have foreseen third parties. These are those who are not specifically identified but known to the auditor. Examples would be the existing creditors of the client. They are not specifically identified, but the auditor knows their general identity. And then we have what we call foreseeable third parties. These are the parties farthest from the auditor. They have a reasonable need to rely on the financial statements, but they are the furthest removed from the contractual agreement. Examples of these are potential investors and bondholders. Now, the contractual relationship exists between the client and the auditor. They have what we call privity, so to speak. This is also the case of the third-party primary beneficiary. These parties are covered by the privity doctrine. Because of this, only they can sue the auditor for breach of contract. The other third parties do not have this right, mainly because they are not privy to the contract. I repeat, only the client and the third-party primary beneficiary can sue the auditor for breach of contract. In fact, because they have a contract with the auditor, they can sue the auditor for ordinary negligence or the failure to exercise reasonable care in performing services, including departure from auditing standards and violations of confidentiality. Foreseen third parties and foreseeable third parties, on the other hand, need the tort law to bring legal action against an auditor. The tort law is invoked in cases where there is an alleged injury due to negligence, gross negligence, or fraud. When we say gross negligence, this means the lack of minimum care in performing services. This involves reckless departure from auditing standards. In some instances, courts have found gross negligence to be equivalent to constructive fraud, meaning there is no intent, but the recklessness with which the audit was conducted is equivalent to fraud, even in the absence of intent. For foreseen and foreseeable third parties, they can bring legal action against the auditor in cases of gross negligence and fraud, whether actual or constructive. Let's illustrate this one. Suppose an auditor is engaged to audit the financial statements of FGH Corp. The auditor was made aware by the board of directors that the audited financial statements will be used by the company in obtaining a loan from the Bank of Funds. Unknown to the auditor, FGH Corp was able to receive 100 million pesos from an investor who relied on the audited financial statements and the audit report. In other words, although it is reasonably expected for investors to use the audit report in making its decisions, the company did not specifically make known to the auditor that his report will be used for this purpose. Now, unfortunately, the external auditor failed to meet the requirements of the standards in the conduct of this particular audit. In fact, he merely signed the audit report without an actual audit taking place. Because of this, the client defaulted on its bank loan and the investor suffered losses. To whom is the auditor liable to? He is liable to the client and the Bank of Funds. We must remember that the minimum cause for legal liability for those with privity is ordinary negligence. Since the auditor is obviously guilty of gross negligence, all the more reason that he is liable to the client and the third-party primary beneficiary. The auditor is also liable to the investor. Under the tort law, the auditor is liable even to a foreseeable third party for injury owing to auditor negligence, gross negligence, or fraud. But what if the auditor performed the audit according to the standards, only that despite this, he was still not able to detect material misstatements? Say, for example, the sample that he chose was not representative of the whole population, and has thus led him to conclude that the financial statements are fairly presented when they are not. Is the auditor liable to the investor? The answer is no. The auditor performed the audit in accordance with the standards. This means he was not negligent. That means he is not liable. Is he liable to the client and the bank of funds? Again, no, because again, he was not negligent. But then they suffered losses owing to the reliance on the audit report. Wouldn't that count for something? Well, remember reasonable assurance? Remember audit risk? Even when the auditor does the audit right in the very best way he can and in accordance with the standards, there is still that risk that the opinion is inappropriate. An auditor can only be held liable if there is audit failure. An audit failure only happens when the auditor abandons the standards of practice. An auditor, therefore, cannot be held liable for as long as he performed his audit in accordance with the auditing standards. Now, let's talk about what needs to be proven in a court for an auditor to be found guilty of the charges that may be brought against him. There are basically 4 criteria. The auditor has a duty of care to the plaintiff. This means that the plaintiff must be either a client, a primary beneficiary, or a foreseen and foreseeable third party. Number 2, there is deficient auditor conduct that led to audit failure. Number 3, that the plaintiff had damage or loss. The loss to the plaintiff must be real loss, not simply an opportunity loss. And number 4, there was reliance on the financial statements or the advice given by the auditor. It must be established in court that there is a causal connection between the auditor's negligence and the plaintiff's loss. Who has the burden of proof for these 4 criteria? Well, the plaintiff has the burden of proof. How does the auditor minimize his exposure to legal liability? There are a number of things that can be done. For example, and we've mentioned this before, choose your clients well. Utilize the engagement letters to help minimize exposure. For example, include a provision that the client has to get consent from the auditor in cases where his report is used for debt or equity securities offering. The auditor has to follow the standards. I cannot stress this enough. For as long as we conduct our audits with due care, follow auditing standards, exercise professional skepticism, we should be confident that we have provided our best service to our clients. And of course, the auditor can seek other remedies such as having a professional liability insurance coverage and having his own legal counsel. So that's it, folks. Thank you so much again for watching our videos. I hope that they were able to clarify stuff for you and have simplified the concepts that we need to learn regards fraud, error, non-compliance, and the auditor's legal liability. Stay safe and healthy, everyone. Hope to see you soon.